Senior Advocate of Nigeria, Adebaro Adamson, joins us now for more. And Godfrey Eshomoge has laid the backdrop for us there. So, so good to have you on Newsnight. The question is, at what point really, should our courts consider a matter of, national importance, give it the kind of urgency that is required in a way that it fast tracks, the cases instead of this slow motion that we seem to be seeing?
Yeah, you are the one calling it slow motion.
Okay.
There are several factors you have to look into when it comes to the procedures of court in getting justice. Mind you, the fundamental thing in court proceeding is fair hearing. I remember I said it here that at all times, people blame judiciary, the court, for delay in dispensing of justice. And I said, this is very wrong. That you look at the role played by the claimant and the defendant and the court. Yes, agree. But with particular reference to the matter at hand, what you need to look at is this. The claimant has gone to court to ventilate his grievances. Now, the defendant will not fold his hands, particularly when there is a provision in the Constitution that says fair hearing must be given to all the parties. Right. And every court has its own procedures. And that's why we have rules of court. Now, the rules of court must be obeyed. If, for instance, you are given 21 days to reply as a defendant to a suit filed against you, then you have the right to exhaust the 21 days. So you don't blame anybody here. Maybe you blame your law. Or you call for amendment of the procedures. Luckily enough, I can tell you for sure this one, that the FCT, High Court, is undergoing a review of its rules of court. The last rule of court we had was 2018. Now there's a review of that rule to accommodate some things that have come up, particularly with reference to justice. And we have come up with a lot of suggestions. Right. And when the final result is out, everybody will commend it. So you don't just blame judiciary, judiciary is foot dragging, they are not doing this. Now, if, for instance, I give an example. I was in a court sometimes. A lawyer wrote a letter and said he was indisposed. A matter was supposed to be heard that day. A very important matter. And it was the last day of our legal year, 19th of July. And he knew that if that procedure was stalled, then nothing will happen until September. So it's antis of the lawyers. But it's allowed under the law. Now we have to subject the word indisposed into interpretation.
There you go.
So by the time we interpreted this, so it's slightly unwell or not willing. So after the divination, my Lord said, at any rate, we just have to give him fair hearing. Here we are. What do we do? So you cannot, at that point, force the defendant to come to court, particularly when he was not in court. Do you blame the court for that? No.
It just looks like deliberately leaving some kind of loophole to wriggle out. Or, how does this work? For instance, the case of Rivers, looking at what's happening in the legislature there, our constitution provides for some kind of reprieve through the National Assembly. I see the smile on your face, but it doesn't look like that is being looked at the moment. Let us in, through your legal expertise, on at what point do you think that the legislature of Rivers State can be subjected to that aspect of our constitution?
There are several provisions in the constitution that are tempting to suggest that at this stage, in the event in Rivers State, the National Assembly should step in. No doubt about that. If you look at the section 11 of the 1999 Constitution, subsection 4 and 5, it is clear that when the House of Assembly of a state is unable to transfer the business of the assembly, the National Assembly can come in to legislate for that state. That is one. that if you look at the provisions of Section 305 of the 1999 Constitution, again, it gives the president to proclaim, to make a proclamation of a state of emergency in a state when there is an actual breakdown of law, of public order, and public safety, or when there is a threat of same. Now, and once that is done, the National Assembly will take over the lawmaking of that state. Now, if you look at the whole scenario here, one will be tempted to say that at this stage, it is proper and normal for National Assembly to take over the legislative functions of House of Assembly of Rivers State. But wait a minute. The matter we are discussing here have been submitted to courts for adjudication. Now, we read why a matter commenced. Somebody went to court to challenge the 26 members of the House of Assembly, saying that they've decamped, so don't recognize them. The High Court of Rivers State granted it. It was appealed. In the Court of Appeal said, look, High Court, what is your business? You're an officious interloper, meddlesome interloper. Meddlesome interloper. And to this extent, you have no jurisdiction. Now, that matter has been appealed to the Supreme Court. It's still pending. Now, mind you, there are other 2 cases at the Federal High Court questioning whether those 26 House members could still be recognized as members of the State Assembly. Now, at this point, can the National Assembly say it's taken over while the judiciary has not exhausted the power imposed on them? They have to wait.
Right.
Now, the question again we have to ask ourselves.
So many questions.
Yes, we ask ourselves.
Right.
Now, is it fair for those constituencies of the state whose members, whose representations cannot perform the function they've sent them to do in the House of Assembly? Now, only 3 members of the House of Assembly of Rivers State are carrying out transacting the business of the House. Will it be fair to those other constituencies? And I give a representation. And I give a sample.
But before we I mean, because of time, okay. Time.
Right.
In the case of Kano State, for example, as some would say, the court has no business deciding who should be emir and who should not be. You still have that case, pending. How does the Constitution envisage that you resolve that matter? Where right now it looks like there are 2 emirs in Kano.
Well, as far as I'm concerned, there's no 2 emirs. There's just one.
Right.
It's one. The law, I have said it here again too, that the law had been amended to say, look, we are scrapping those other Emirate units, and we have 1 now. And consequent to that law, the governor of Kano State appointed Emir Sanusi. But there was a controversy as to his appointment, as at the time of his appointment, whether it was cut off by the order of the court or not. Now, the question is this. If there is a court order that is directed to a particular person, that person must be served personally. That's the question here.
Right.
Was Emir Sanusi served personally?
That's a question.
It's a question. Now, the governor that was at the center of it all, was he equally served personally? Those are the issues here. Now, until and except all these things are ironed out on appeal, we cannot see anything here.
Yeah, we'll have to leave it there. Adebaro Adamson, Senior Advocate of Nigeria.
Thank you
Always a
very much.
delight having you on News Night and helping us understand these issues.